Okay, so thanks ever so much for coming this morning. I'm just going to wait another 2 minutes to see if anybody else joins, and then I'm going to start the webinar. Adam's helpfully noted that the best way to get in touch with me if you want to speak to me during the webinar is through the Q&A box, and I am happy to take any questions that you pose at the end of the webinar. I'll see if I can answer them. I might not see it straight away, but I'll check it regularly when I change slides so that I can see if anybody's having any difficulties. So, good morning, everyone, and welcome to this webinar on contentious probate and settling contentious probate disputes. I am going to talk, just have to start my slideshow from the beginning. Thanks very much. So I'm a barrister specialising in contentious probate, contentious court of protection work and contentious tax, and I do a little bit of private client advisory work as well. Adam's kindly asked me to give this webinar to you on settling contentious probate disputes. I'm going to talk about contentious probate disputes, strictly so-called, so challenging the validity of a will. I'm also going to talk a little bit about 1975 Act claims, and I'm going to touch on some issues to do with taxation that are a bit wider than that. You may know that the Five Stone Buildings webinar program has been ongoing throughout lockdown and will be continuing. I have been doing webinars on basic IHT, COVID court hearings, and I recently did a common intention constructive trust webinar with Liza Eagling, and I do recommend, if you are new to the area, and Adam's told me that there are some trainees in the department, you might find the inheritance tax basics webinar helpful for you, because lots of issues to do with the settling of contentious probate disputes deal with contentious issues that play into inheritance tax, so that might be helpful. And all the webinars are recorded and put on the website and our YouTube channel. I think if I had known that our Five Stone Buildings would have its own YouTube channel 6 months ago, I would have been extremely surprised. So I think that having a background in advisory work has really helped in settling all manner of contentious probate disputes, because it's very helpful to find the most tax efficient manner of settling a dispute. It's helpful to know about spouse exemption, charity exemption, business property relief, and the residential nil rate ban now. But we're going to leave the tax issues to a little bit later in the talk, and the talk is going to comprise discussion about grants of probate, forms of settlement, contracts, deeds of variation, Tomlin orders, trial on the written evidence, discontinuance, and Section 49 of the Administration of Justice Act 1985. I'm going to talk a little bit about the introduction to the mix of children and protected parties, and then I'm going to focus some more on the tax issues, although some tax issues will inevitably come up, particularly in discussing deeds of variation. But the tax issues later on will be some of the tricks that you can use to improve the client's tax situation. So, what kind of grant do you want? This isn't the best picture of Hugh for these purposes, because he doesn't look really solemn or common in it. You'll be aware that there are different forms of grants of probate that you can get. You get a common form grant out of the principal registry or a district probate registry, and it can be revoked later. So That is the disadvantage. The advantage is that it's reasonably straightforwardly obtainable. A solemn form grant is what issues once the High Court, the Chancery Division, has made decisions on whether a will is valid, and it admits the will to probate in solemn form. And that is a pretty cast iron grant of probate. The court is essentially acting in rem when it makes that grant of probate. And so unless somehow the proceedings that led up to the grant of probate are undermined in some way, that will be a rock solid cast iron grant of probate, which you might want, particularly if there are some people that you think might come out of the woodwork, or you can't bind everybody into agreeing that your common form grant will not be opposed or revoked. So that's something that you're going to want to bear in mind at all times when you are considering how to settle your contentious probate dispute if you're dealing with the validity of a will. So what forms of settlement are available to you? Well, there are a number of different ways in which you could settle contentious probate and 1975 Act claims. You can just have a normal settlement contract, which might be a deed but doesn't have to be. Obviously, if land is involved, you're going to want signed writing, and if land was involved, I would want a deed. There's a deed of variation, which is shorthand for a deed that complies with Section 142 of the Inheritance Tax Act 1984. And this is potentially retrospective for both IHT and capital gains tax, CGT purposes, provided it's entered into within 2 years after death. There are some wrinkles with using a deed of variation to settle a proper contentious probate dispute. It's certainly the case that you can settle a 1975 Act claim by way of a deed of variation. HMRC have a specific concession which says that this is permitted. One of the things that you're not able to do under Section 142 of the Inheritance Tax Act is use consideration, and consideration will mean that the tax retrospectivity is lost for the deed. So HMRC appear to consider from their concession in relation to 1975 Act that settling other kinds of dispute would be consideration for the purposes of Section 142. So this is an issue if you're trying to settle a claim that a will is invalid because of lack of capacity, want of knowledge and approval, forgery. It's not clear why the HMRC would want to argue that consideration that's internal to the estate, so doesn't come from a party's outside resources, would be consideration for the purposes of Section 142, but there is a risk, and so in general I tend not to use deeds of variation if the tax retrospectivity is definitely required. Although in general I'm a bit more relaxed, I think, than some people about whether it is necessary to have the tax retrospectivity in a deed of variation. Certainly it's possible that it could be useful for capital gains tax purposes if there's been a rise in the value of the estate since death, and some people think that there is a risk that when you deal with your interest in an unadministered estate, that's a disposal for CGT purposes with a nil base cost, which would obviously be a bit disastrous. However, I've known people talk about this since before I think I was a pupil, and it's not my understanding that the revenue takes this point. And the inheritance tax, people are often concerned that they'll be making some kind of potentially exempt transfer, but in my view, if a contentious probate settlement has been properly negotiated and is a real dispute and has been bona fide settled, then I don't think there's going to be any gratuitous intent, so I don't think there's likely to be a transfer of value for inheritance tax purposes. So if you're not using a deed of variation, you might consider using a Tomlin order. These are particularly useful if your claim has already begun, because they will allow you to enforce the terms of the Tomlin order without starting fresh proceedings. I find that they're particularly useful in 1975 Act claims, but there are equally issues to do with inheritance tax and capital gains tax involved in the drafting of them. This is because it's necessary in order to get retrospectivity again for particularly for CGT purposes, to have an order under Section 2 of the Inheritance Provision for Family Independence Act 1975. Otherwise, the order will not qualify under Section 19 of the Inheritance Family Provision Act for that retrospectivity, because there's no, although there is a set part of the Inheritance Tax Act which allows for specific retrospectivity, which we'll talk a bit about later, where a claim under the 1975 Act has been made, there's no provision in the Taxation of Capital Gains Tax Act for that. So you want to get an order out of the court under Section 2. You probably don't want to have a hearing. So how do you deal with that? And the way I deal with that is by having an order that looks pretty similar to a Tomlin order, but instead of providing that the executors agree to be bound by the terms of the schedule within the Tomlin order, what I do is I require the executors to put in place the agreement under the Tomlin order and require them by court order to abide by it. And in my experience, that will allow for full IHT and CGT retrospectivities. And I've always been slightly concerned that it might be necessary to go to court and ask the court to make the order, and for the court to ask difficult questions about whether it can or can't do this, what I've put in the schedule to the Tomlin order under the Act. But in practice, it's my experience that judges simply sign off on the orders, but I think that it does provide a solid basis for the tax retrospectivity. So that's very useful practical tip. Moving on from 75 Act claims, what if you've got a claim that's in progress for will validity challenge? Well, then you're going to want to take particular care to look at Practice Direction A to Part 57, and in particular paragraph 6.1, because these adumbrates the 3 ways in which you can discontinue a probate claim that's already on foot. And by discontinue, I just mean finish. One of the ways is true discontinuous. You can discontinue, and you can do that in fact on terms, but you will end up just asking the court to discontinue, and then it will discontinue, and that will lead to a grant of probate in common form. However, if you want a grant of probate in solemn form, there are 2 ways to get that without a fully contested hearing. The first way is under Section 49 of the Administration of Justice Act 1985, but this requires the consent of every relevant beneficiary to the order. And this means that you will have to have everybody who is interested in the wills that are being challenged, or under an intestacy if the challenged will would then lead to an intestacy. And that's fine if you have everybody, but often in my experience, you won't have everybody on board, because there might be a child or a protected party or some unborn and minor beneficiaries under a trust, or there might just be too many people in the class, you haven't gathered them all together, or there might be some legacies that haven't been legacy beneficiaries that haven't been joined that might prevent you having this Section 49 order. So it's good if you have every relevant beneficiary able to sign up. If you don't, and you really want a grant in solemn form, there's only one way, and that's a trial on the written evidence. So the reason why you wouldn't just go for trial on the written evidence as a default solution to getting a grant in solemn form is that it's a bit more expensive because you have to have a hearing, it's a bit more time consuming because you have to have a hearing, and it's a bit more unpredictable because the judge is actually going to be looking at the evidence to see if they can make a finding that the will that you're asking them to admit to probate is the last valid will of the deceased. In practice, I haven't actually had any difficulty getting the judgment from a judge on the trial and the written evidence, but clearly it does involve an additional element of risk. But if you do want to grant in solemn form and you don't have every relevant beneficiary, it is the only way, and I don't think it is as risky, having done it and seen other people do it a number of times, than I first thought. So those are the ways of settling a on-foot contentious probate claim. You can discontinue and you'll get a grant in common form, or you can obtain an order under section 49 if you have all the relevant consents, or you can get a trial on the written evidence. It's also worth noting that in some cases, settlement is made essentially by distribution out of a discretionary trust, or a trust where there are powers to distribute capital to either the life tenant or other parties. This can be particularly useful if there's a flexible life interest trust and there's a 75 Act claim by the widow who's a beneficiary, something like that. It's worth noting, firstly, that the trustees might consider that they want a blessing for the decision, because they might feel that it's a particularly momentous decision, in which case they're going to want to get a kind of directions from the court. It's also worth considering, if you're acting for the beneficiaries, that theoretically it's quite difficult to bind the trustees into exercising their discretions in a particular way, because obviously trustees are not able to fetter their own discretion. What I usually do in these circumstances is negotiate a Tomlin order, where the court appends the draft trust documents that we want the trustees to execute, so an advancement or an appointment, to the Tomlin order. And whilst I have been concerned that the trustees might renege on that, in practice that has never happened to me. So, and that's maybe not surprising, because if the trustees are willing to agree to the settlement, they're probably going to execute the documents that they have signed up to. But there is a slight complication in that regard. But I think that having all of the documents agreed and prepared, ready for execution, before we put the document into the court, is definitely the best way of ensuring that there aren't any post-order difficulties caused by the trustees or any other party. So I did mention children and protected parties, and as you'll be aware, there's an entire code in the civil procedure rules in part 21 dealing with the settlement of disputes involving children and protected parties. You're always going to want an order from the court approving the compromise on behalf of the child or protected party. That's going to be supported by counsel's opinion that it's for the benefit of the children or protected party to authorise the compromise on their behalf. If you don't have proceedings already on foot, you can bring a Part 8 application specifically for the purpose of obtaining a order under Part 21 approving the compromise. I always do this in the way of a Tomlin order. I have seen parties try and negotiate a sort of freestanding agreement, which they then want the court to authorise on behalf of the child or protected party. This makes me extremely nervous. Often there are things within this, like indemnities given by the child or protected party, and I feel also very nervous about the ability of the litigation friend and the court to bind the child or protected party into this. It's certainly possible to go to the Court of Protection to bind a protected party into positive obligations that are ongoing, like an indemnity, but children are much more complicated. And if anybody's interested in the quite arcane law dealing with how you manage children's property, I can recommend the volume in Hallsbury's, which deals with it in some detail, but it's very tricky. So if I'm acting for a litigation friend, I'm pretty reluctant to agree any ongoing positive obligations. Obviously, if it's a claim against a child or protected party, you might agree that a sum of money be paid in compromise of that dispute, but the sort of indemnities that I've seen, I'm very reluctant to agree to. Also, it's the case that if you have a representative beneficiary in your dispute, which you might have because you might have a discretionary trust where the trustees don't want to or can't for some reason represent the class, you may then get one of the members of the class representing all the other members. They can only settle a dispute with a court order just in the same way as a child. That's not provided for under Part 21, that's provided for under Rule 19.5, which deals with representative beneficiaries. So do be aware of that. If you have a representative beneficiary, you're going to need a court order. And I've seen that happen recently because I had quite a complicated 75 Act claim where that was what the trustees wanted. They couldn't, because they had a personal interest in the claim, they couldn't represent the class, so they got one of the children to act as a representative beneficiary. And there were difficulties because the class was quite wide and there were different sort of interests within the class, and it did look like there might be difficulties in getting an opinion which said that the whole class benefited from this settlement. The trustees dealt with that by exercising their powers to benefit part of the class. So there was a resettlement, which the people who were now within the smaller class were able to get an opinion for the representative beneficiary that the settlement was for their benefit. So there are ways in which the trustees can manage their class in order to allow representative beneficiaries to get opinions that benefit, so that a compromise benefits the whole class. So that's something to bear in mind as well. So moving on to some issues to do with spouse exemption, which is particularly relevant in my experience in 75 Act cases. I want to talk about a technique that is common and very useful to exploit Section 146 of the Inheritance Tax Act, which, as we noted earlier, provides retrospectivity to orders made under the 1975 Act for IHT purposes. So let's imagine a situation where first there's two marriages of the deceased. One ended in divorce and the second one ended in death. There are two children of the first marriage and there's their stepmother. The deceased left terminable, flexible life interest trusts of residue to his widow, and there are potential to benefit the children of the first marriage as to capital and in remainder. So this is very tax efficient, provided the spouse is a UK domiciled or deemed domiciled. It's important to remember that there's a limitation on the benefit under Section 18 of the Inheritance Tax Act for spouses who are non-domiciled. And I've actually got a case where the deemed domicile extensions to 5 years are actually helping us claim a spouse exemption in one case that I have at the moment. So the whole, prima facie, the whole estate is spouse exempt, and what you want to do is carve it up in the 75 Act dispute, because despite what Mr. Justice Mostyn said in first instance in Cowan, the spouse definitely doesn't think that a terminable life interest is sufficient financial provision for her. What you want to do is split the capital so that the spouse gets a lump sum and the children both get lump sums. You can do this in a very tax efficient way by retaining the life interest that the spouse has until the date of the Tomlin order that you've drafted, compromising the proceedings. This will mean that the entire estate continues to be spouse exempt on the death of the husband. she will need to be paid the intermediate income arising down to the date of the Tomlin order. There won't be any additional IHT payable as a result of the termination of her life interest, because of the way in which section 146 works, which provides effectively that there isn't any additional tax to pay because of the following the effect of the order made under the 1975 Act. And that means that she doesn't make a potentially exempt transfer when her life interest in residue or part of it terminates. In normal circumstances, she'd have an immediate post-death interest in possession, which when it's terminated is a deemed potentially exempt transfer, so that if she dies within the next 7 years, it will be brought into account for inheritance tax purposes and will likely use up part or all of her nil rate band. But because of section 146, this is a nothing for IHT purposes. So if she dies within 7 years, that pet won't have been made. And it's obviously why we're talking about pets, that we have a lovely picture of Leo the tax cat in the corner here. He's my pet. I have heard it said that some people have advised that you can create a life interest for a spouse by way of the settlement of your 75 Act claim and terminate it, with the result that you can obtain spouse exemption on the death of the deceased and a nothing when that spousal interest is terminated. In my view, that looks to be a little bit too good to be true. I would certainly advise that there was a risk involved in that, and I would look to how the spouse was going to deal with the inheritance tax liability if the planning turned out not to be effective, because I think that there's a very significant risk that if the revenue noticed it, that they would argue it was artificial and came within the Ramsey case law, so that you look through it even if some intermediate income had been paid to the spouse. So obviously the best way in which you might substantiate planning like that would be to make sure a substantial amount of income was paid to the spouse, on which she paid income tax. But I would be quite concerned about that kind of planning, and I do think there's a real risk on Ramsey, or potentially the GAR, the general anti-avoidance rule, that would be ineffective. But it certainly is very effective where you have a pre-existing life interest, which might come from the will, or it could come from an old intestacy where the deceased spouse got life interest in half. So that's spouse exemption and section 146 and the tax planning tool available. Another useful tool in settling contentious probate disputes is the charity exemption under section 23 of the Inheritance Tax Act 1984. So as you're no doubt aware, there is a general charity exemption which allows charities to take property without tax being paid on it. This technique arises where you have one will benefiting an exempt beneficiary, like, I don't know, the National Trust, and one will benefiting a non-exempt beneficiary, like, I don't know, the children of the deceased. And what you will want to do is you want to admit the charity will to probate. This is particularly useful where the last will is a charity will, but you can still use it if the last will is not the charity will, but you want to take care how you are going to deal with the probate registry in respect of the scripts. So there are a number of ways in which you have to take care in dealing with this. So let's imagine you have a will for Janet and John, the deceased children, in 1998, and you have a 2008 will in favour of the National Trust. You negotiate a settlement whereby half the estate is going to go to Janet and John and half the estate is going to go to the National Trust. I've just picked the National Trust out of the air as a possible charity. They've been in the news recently. And what you will do is you will seek to get charity exemption on the whole of the estate, not just the part that's going to the National Trust. You will do this by taking care not to fall within any of the avoidance provisions in Section 23 of the Inheritance Tax Act. This means that the National Trust cannot use its own resources to pay off Janet and John. Janet and John have to get their interest from the estate in the due course of administration. And you will so the way in which Section 23 seeks to protect the revenue here is that it says that all the property that is going under Section 23 as charity exempt needs to be used for charitable purposes. And what I have done in the past and what has worked is to argue that the amount that's being paid to Janet and John from the deceased person's estate is being used for charitable purposes, because although it isn't actually going to the charity, it's part of the charitable purposes of the charity to deal with contentious probate disputes which commonly arise, particularly for large national charities, and that what's happening is that there's been a fair payoff of Janet and John through a negotiated commercial settlement, and therefore that money is being used for charitable purposes to pay off a contentious probate dispute. And so that makes the settlement for the charity much more palatable, because they only have to pay 60% of the amount that's actually going to Janet and John, because they retain the charity exemption. So that's a very effective way of making settlements more palatable for charities, and for settling those kind of will validity claims. So I'm going to also deal a little bit about tax issues that arise in proprietary estoppel and mutual wills claims. I don't know whether you necessarily, strictly speaking, call them contentious probate disputes, but they're pretty similar, and I hope that you'll be interested in what I have to say about this. So what you can do, particularly if you're on the receiving end of a proprietary estoppel or mutual wills claim, although if you have an entire mutual wills claim, you might not be very interested anymore if you think that the claim is valid in the rest of the estate. But if you have this claim being made against you, you can make an argument to the revenue that because of the alleged equity that exists in relation to the deceased estate already at the time of death, that the transfer of value that's deemed to be made on immediately before the death is impaired by, or completely extinguished by, the existence of this potentially valid claim to the deceased's assets. Certainly theoretically, if you have a proprietary estoppel claim, I don't know, to say a farm, then the deceased dying without a will in place that gives the farmer, like in Thorner, I guess, the whole farm is an unconscionable act, and that unconscionable act appears to happen possibly before the date of death, so there may be an equity that is already attached to the property within the estate when it gets transferred to the executors. There's a really interesting discussion about this in some articles in Private Client Business by Christopher Whitehouse and Penelope Reed QC. So if you're interested in this, I would suggest that you have a look at those articles, which you can find on Westlaw. And in my experience, although it is arguable that the entire estate can be taken out of account by reason of the proprietary estoppel or mutual wills equity, in fact, the revenue won't accept that full argument, but they will accept that there's an impairment to some extent of the value of the assets being transferred on death because of the possibility or actuality of a claim against those assets. And so you can get a reduction in the inheritance tax payable as a result of that, although you can't get, at least I haven't been able to get myself, the full amount of reduction. So that's another way of seeking to use your sort of dispute to reduce the tax liability overall. So I just wanted to have, before I finish the main part of the talk and invite questions, just wanted to have a quick word about preparing for mediation and tax issues. So I think that often mediations in contentious probate and similar disputes can get derailed because one side has an advanced understanding of how they think that the compromise can be achieved using one or another of the techniques I've suggested earlier in the talk, or some other jolly tax whiz that they've come up with. And the other side are unaware of that, and then they don't have enough tax support at the mediation in order to agree it, because it makes them very concerned. And therefore I do think that it is definitely worthwhile considering well in advance of a mediation what sort of structures you would like to use, or the other side might like to use, and what tax consequences they might have, so you can have the advice at your fingertips during the mediation. So is there a possible capital gains tax charge? Is there a gain on the property? What are you disposing of it? Is it likely that someone's going to want to buy someone else out of a property? Is that going to cause an SDLT charge? Is it going to be at the higher rate? Very worryingly, is there possibly a corporation tax charge? Sometimes I litigate corporation tax, but I definitely do not think the Bar Mutual would be at all happy if I started advising on corporation tax. This does occasionally happen. I've had, for example, a farming proprietary estoppel dispute where the properties were held in farm companies, and a keen accountant had suggested that we could deal with this issue by having a demerger of the company. Apart from having to knock up my corporate skills and remind myself what a demerger was, I also had a good look at the tax advice and thought this looks far too good to be true. I was extremely worried about the accountant's corporation tax advice. And so what I suggested before the mediation was that we got tax counsel's advice. We actually got it from Oliver Marr in my chambers, who often does kind of less standard tax advice for settlement for me, and it did turn out that the accountant's advice was too good to be true, and I was really happy that we had bottomed out the tax consequences before we went to the mediation. If you get to the point, and sometimes it does happen, that you will be bounced by some kind of settlement structure that you haven't anticipated, particularly if there's some kind of overage agreement or something like that that you hadn't expected the other side to want. You might consider putting in heads of terms rather than a binding Tomlin order at the end of a mediation. I'd always want a settlement agreement or Tomlin order at the end of a mediation if I can get it, so the other side can't wriggle out of it the next day when they realise that you've managed to negotiate an excellent deal, or your client can't have cold feet despite the fact that they managed to negotiate an excellent deal. That is a possibility, and something that you can consider as well as getting tax counsel's advice is whether your firm is able to provide any tax advice itself, because your firm might have a much wider tax experience than you do as a private client contentious department, in which case that's great, and I really appreciate the help of firms' private tax departments, but it's wise to put them on notice that you might want their help and give them an idea about what the dispute is beforehand, because what you don't want is to be phoning up your tax partner at 9:30 in the evening where they just sat down to watch Line of Duty, only to be found that you want them to assist in your mediation. So keying up tax advice in advance is a great idea. So just to recap, what we have done is look at the different grants that you might want to get in a contentious probate dispute. We've had a look at the forms in which you might get a contentious probate settlement. We've had a look at just a simple contract, a deed of variation, but we've noted that there's a risk in consideration if you're settling any dispute that isn't a 1975 Act. We've looked at a Tomlin order and how you can convert a Tomlin order into an order under Section 2 of the Inheritance Provision for Family Independence Act 1975, so you can secure retrospectivity for IHT and CGT purposes. We've had a talk about the different ways in which you can settle a contentious probate dispute, strictly so-called. We've had a look at the ways in which you can get a grant in solemn form by agreement under Section 49 of the Administration of Justice Act 1985 and by way of a trial on the written evidence. We've also had a short talk discussion on how you might use trustees' powers to settle your contentious probate dispute. We talked about children and protected parties and some particular tax advantaged way of settling claims under the 75 Act and contentious probate disputes that involve charities, proprietary estoppel and mutual wills. And we talked a little bit about how to mediation. If anybody would like to ask questions, they can do so using the Q&A box now. If you'd prefer to remain anonymous so that your colleagues don't find out you're asking, then do use that. So Adam has asked a question, which is that he says he thinks that the received wisdom is that a genuine life interest for 2 years with income paid is sort of safe, but not cast iron. There is often insurance in place. What do you think about that? So yes, I agree with that entirely, that a less than 2 year interest in possession is going to have difficulties because of Section 1, possibly Section 144 of the Inheritance Tax Act. So I do think you need a life interest which has income bearing for at least 2 years. There was some revenue guidance in around 2007, which I think has now been rescinded, which suggested that if you had a life interest of more than 5 years, that would definitely be fine. But in fact, I have never had any problem with dealing with a life interest that is over 2 years. You do definitely need to provide the income payable to the spouse. So I don't think that that's a problem. There is often insurance in place. If you are advising the spouse in that situation, you're going to want to look at what the additional costs of a termination of the life interest, which will be a pet in those circumstances, will be. So they are the likely use in whole or in part of her nil rate ban, so she won't be able to use that if she dies for the benefit of her children, assuming that she has different children from the other beneficiaries of the estate, and also a possible additional IHT charge for her estate. Therefore, I have frequently arranged for life insurance for 7 years. You can, if it's a large transfer, then you can get a decreasing term to deal with the taper relief. Quite how you hold the insurance policy is an interesting question, because you might well not want to put it in her estate, because that's going to augment her estate for inheritance tax purposes. And I have sometimes seen these written into trust, but of course you don't want to cause an immediately chargeable transfer for inheritance tax purposes by creating a freestanding valuable trust. I mean, often they won't be worth anywhere near as much as her nil rate band, but you know, they can be valuable, and you don't necessarily want to create a freestanding trust. Sometimes the trustees, if you're creating a settlement out of the estate in the way Adam's suggesting, you can get the trustees to hold the policy and have separate sub-fund terms for the holding of this policy so that it's available for the widow's estate. But they can be quite interesting and tricky drafting issues to deal with. But thanks for that question, Adam. Are there any other questions? Just wait a second in case there are any other questions. Okay, I don't seem to be getting any additional questions, but if you do have any questions that come up in your mind as soon as you close down your monitor and go and have a well-deserved cup of tea, then please do feel free to email me and rhughes@5sblaw.com, or you can email the clerks and ask them to send any questions to me. So thanks ever so much to Adam for inviting me to do the webinar, and thanks ever so much for everybody for tuning in this morning, and do consider watching Five Stone Building's regular webinar program. So hope you have a great day and you get some chance to enjoy the sunshine.